We're giving a preview, everybody, of the upcoming Supreme Court argument tomorrow. We have, in fact, represent the Heritage Foundation. We're involved in this case. Obviously, we've filed 2 sets of briefs, and the oral argument is, in fact, going to take place tomorrow starting at 10 o'clock Eastern Time. There's 2 cases, so it'll go at least to when we're live, noon. We will then give commentary as it develops. President Biden said, and if we have that sound, I want to play it right now. He said there is no federal solution to COVID.
Look, there is no federal solution. This gets solved at a state level. I'm looking at Governor Sununu on the board here. He talks about that a lot.
I rarely agree with President Biden, but I will fully concur with that. There is no federal solution that gets resolved on the state level.
We made that the opening salvo, if you will, on behalf of the Heritage Foundation's reply brief to OSHA, that there is no federal solution. In other words, in legal terms, there is no federal jurisdiction. As Professor Hutchison said, this is a problem of federalism.
The idea, and of course, the Commerce Clause, the idea that this is a unique power, police power resting really with the states, and that OSHA itself isn't the entity to be implementing this, as OSHA basically acknowledged early on.
If you look at the 10th Amendment clearly, if you look at the federalism issue clearly, we have clear and unmistakable precedents suggesting that states are the appropriate venue for dealing with a pandemic in a Republican form of government.
If you're not vaccinated, you have to get a test that says negative if you go to work, and you wear a mask in your workplace. Except Dr. Fauci is saying testing is going to be a problem.
We don't have enough tests at this particular point in time to get everybody uniformly have the availability of testing. That will change considerably as we get into January. Well, right now,
if you
just
find
keep
a test,
trying. Jim, you can't do the impossible. If you can't find it, you can't find it. You just keep trying and doing your best.
Yeah, but they got a mandate that has penalties with it if you don't find it.
A stunning lack of clarity, and of course the message keeps changing too. And I'll say it again, and you've said it, this authority really needs to rest with the states. Our founders feared a large central government as much as they feared an absolute monarch.
Where I'm concerned is we're in legal no man's land here. I mean, because as the argument goes forward tomorrow, there is no stay. So Dr. Fauci says if you can't comply, you can't comply. I wish he could issue that from OSHA.
There's a doctrine in the law. You're familiar with it. In fact, you called it to my attention, and that's the doctrine of impossibility. You cannot attack a person. You cannot penalize a person. You cannot criminalize a person who is unable because it's impossible to perform a task. And under the doctrine of impossibility, you cannot penalize a person because he can't get a COVID test.
We're 24 hours away from a very historic case at the U.S. Supreme Court, a case that for the first time in Heritage's history, you all entered in as a plaintiff. Give me your thoughts going into this.
2 thoughts. The first is gratitude to you and your colleagues and wonderful staff at ACLJ for representing us. Y'all are the best. And the second is cautious optimism. I mean, I'm not an attorney, so you can't trust this historian to predict tomorrow's outcome, but cautious optimism because of the merits of our case, built by you and your team, Jay, augmented by the great legal scholars at Heritage. And we're just hopeful that this court, which has become stronger in its thinking, is going to do the right thing and protect the sacrosanct relationship that employers have with their employees, namely by protecting that private information of their employees.
Lack of a stay being issued here is creating havoc. I mean, we ourselves, you and I have talked about this. You're the president of Heritage. We've got the ACLJ here. We have a management team. We're trying to figure out how to start complying with parts of this on Monday because the court has not taken action. Now, I'm hopeful that maybe tomorrow after the arguments that we will get some kind of order from the court that gives at least an administrative stay until they issue a decision. But trying to comply with this in the interim is not an easy challenge.
No, it isn't. I mean, I spent an inordinate amount of time yesterday with a few of my senior colleagues, as I'm sure you have done, and as employers around this country have done, trying to figure out how quickly we can comply in case a stay is not issued. And I just will use the word unjust, Jay, to say that it is unjust that a stay has not been issued while this is going through the courts. And so think about the work you do, the work we do. Think about the work of manufacturers, factories, businesses around this country, they've had to take hours and days to figure out how to comply on short notice, when obviously we've got to have a situation where the federal government is keeping us from doing our business.
We could get an administrative stay issued Friday afternoon or Saturday or Sunday before implementation. They're going to vote Friday. Right from after the argument, they're going to vote. You don't necessarily know the result of that vote until the opinion comes out, but in a situation, this is an emergency application for stay, so it should move quicker. Having said that, it's not in our control.